one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Now allow me to invite our next discussant and the Honourable Justice Pilving, Chairman of the Administrative Law Chamber, the Supreme Court of Estonia, to deliver his response.
Good afternoon, or good morning, or good evening for everybody over the globe. Honourable Chief Justices, Supreme Court Presidents, dear Kari, ladies and gentlemen. First, I would like to thank Dr. Reayat for creating this forum and his generous invitation to contribute it. Dialogue between different constitutional traditions between North and South is needed today more than ever before. And special thanks, of course, to you, President Kuusiniemi, for your honest diagnosis and positive program. Indeed, what should we do to stop the erosion of the rule of law? I fully concur. Maintaining of democracy and rule of law requires constant hard work, even war in its most brutal form, as we must see it already 5th year in Ukraine yet. President Tashutin, I wish you all the best in your new position. And dear Kari, thank you very much for highlighting Estonia in a positive way in this context. Allow me to make few comments on this. Rapid reforms were the key for success of Baltic countries, both transition to market economy, privatization of state-owned enterprises, not for local oligarchs, but also opening the market for foreign capital. However, this all required reliable legal system. The rule of law did not emerge in Baltic states that time from a vacuum. We had experience in building democracy and constitutionalism from the interwar period. Unfortunately, we also witnessed the decline of the rule of law in Estonia even before the Soviet occupation in 1940. Constitutional developments in recent decades have been particularly influenced by the desire to avoid repeating the historical mistakes that once led to a return to autocracy. Estonia's first constitution was adopted in 1920. Its greatest flaw was extreme parliamentarianism. Too much democracy, if I may say so. Combined with the economic crisis, this led to an authoritarian coup in 1934. The 1992 constitution is significantly more balanced in terms of the relationship between parliament and the government. In my view, the current constitution strikes a good balance also between political power and the courts. In Estonia, the role of the Constitutional Court is fulfilled by the Supreme Court. It has broad powers, most notably the authority to invalidate unconstitutional parliamentary acts. Our catalogue of fundamental rights is extensive. However, the right to initiate constitutional review is limited. Although fundamental rights are protected in ordinary and administrative courts, a parliamentary minority, for example, does not have the right to initiate judicial review of laws. Such a right may work well in some countries, but in others, through the politicization of the judiciary, it has failed to provide protection against the erosion of the rule of law. Even worse, to introduce it now may turn to Trojan horse, dragging the courts directly and deeply into partisan struggles. The political parties would attempt much more likely to bring the court under their control. There are currently many threats to stable democracy in our region, primarily due to Nazi Russian widespread hybrid warfare. A very worrying trend is the increase in political attacks on judges for their work, which we have seen practically everywhere in the world: India, Kenya, Ecuador, Estonia, and last but not least, United States. Today, we must avoid any additional risk that could call the credibility and resilience of the courts into question. Instead of granting the courts maximum possible power, their independence should be strengthened and transparency increased. President Kuusiniemi gave us several examples. In Estonia, the government is expected to submit a draft bill to Parliament this week to replace the Minister of Justice's authority over the administration of the courts with that of the Judicial Council. The details are still under discussion. We are currently engaged in a debate over stakeholders who should be represented in the council. Politicians must not interfere with the substance of judicial decisions, but the organization and financing of the courts is a democratic issue too, not merely a business of the judiciary. An absolute lack of political accountability for the administration of the courts might be dangerous. It could lead to underfunding. This could provide a pretext for much stricter control of the courts in the future. Here too, we must strike a balance and avoid extremes which could lead to even more painful reactions later on, just as the history teaches us. Thank you, dear colleagues. Thank you, Dr. Reayat, and everybody in our global audience. Keep safe, everybody, in these turbulent times.
Thank you very much, the Honourable Justice Pilving, for delivering your response.